delete front, I think my colleagues have pretty extensively outlined to the committee what the implications are of each of those. It is, I suppose, the difficulty is the uncertainty created by the simple deletion. Now, you're simply never going to get certainty. I mean, there isn't a single legal provision anywhere that you could say with certainty what it means. But there are obviously degrees of uncertainty. And this is an area where, firstly, and primarily, the women at the centre of the difficulties need to understand in a very time-sensitive way what their rights are and how they can be accessed, and they need to be able to take advice, and it needs to be clear. So it needs, that kind of certainty is very valuable. Having said all that, it seems to me that trying to put complex provisions into the Constitution is just simply impossible, and makes it very difficult to know. You're trying to get very, very complex ideas into a couple of sentences, and it's very difficult to do. And I think the Eighth Amendment itself is a very good example of that, because at the time it was passed, there were opinions about what it meant and what its effects were, which were not borne out over time. And it ended up meaning something different to what a lot of the people who were voting on the issue thought it meant. So it's that kind of thing that, on a practical level, causes difficulties. So I think that having a degree of clarity, so that it's clear that any pre-existing rights are governable by the Oireachtas and everybody knows where they stand, I think there's merit in that approach myself. But that is a matter for the committee as to exactly what you want to achieve and how you achieve it. In terms of the amendment and other cases that have arisen that have nothing to do with abortion rights as such, it is true to say that the existence of the amendment has meant that other aspects of care for women have been captured within the remit of the amendment, and in particular, we had very recently the P and the HSE case where a woman who was deceased and was pregnant was in circumstances where her body was being kept alive in order to keep the fetus alive. And the High Court in that case held that that situation did in fact engage the Eighth Amendment, and that there was a right to life of the unborn in those circumstances, not one that had to be balanced against the right to life of the mother because the mother was deceased, but a right to life in the unborn, and that the evidence in that case was, the medical evidence was unanimous to the effect that there was a high probability that the child would not survive until term, and the fact that the mother had died at the point in the pregnancy, which I think was about 15 weeks at the date of her death, meant that the prospects for getting the fetus to a stage where it was viable was probably nil. And the mother's system was totally collapsing. But so in other words, the clinicians who were involved in those circumstances couldn't apply ordinary principles of clinical practice to the circumstances in which they found themselves, because they were very concerned that if they did so, they would be in breach of constitutional rights and possibly behaving unlawfully because their circumstances were unclear. And so obviously this is an aspect of the amendment that is not covered by the recent legislation, which simply covers how you balance the test in the X case, or provides a mechanism for accessing an answer about whether or not you're entitled to an abortion in this jurisdiction. It doesn't deal with the other issues that might arise. And of course the Eighth Amendment has also been used in other circumstances to suggest that a fetus, an unborn child has certain immigration rights that have to be taken into account by the courts, that an unborn child, that a frozen embryo has a right to life. The Supreme Court held that a frozen embryo does not fall within the provisions of the amendment, or at least in the circumstances that pertained in the Roach case. So in surprising ways, the terms of the Eighth Amendment was, for example, mentioned in the arguments in Oran Thar about surrogacy, where the issue was whether the mother of the child who actually bore the child was to be considered the legal mother of the child, and the terms of the Eighth Amendment were relied on to suggest that that's what that provision requires. Again, not the basis upon which the court made their decision in Oran Thar. So yes, it has had, and the wording has had a lot of unexpected consequences, and that is one of the difficulties about amending and replacing wording, that you have to bear in mind that it can have consequences that may not have been intended.
Thank you. I'll